Mr. Wheatley, good morning.
Good morning, ma'am. May it please the Court, my name is Stan Wheatley. I represent the plaintiff below and the appellant in this court, Kirsten Wheatley, by her mother and next friend, Sigrid Wheatley. In the interest of full disclosure, I am the husband of Sigrid Wheatley and the father of Kirsten Wheatley. And I'd like to begin by thanking the Court for granting direct appellate review in this case. Our view of the correct outcome requires overruling two precedents of this Court, and I think that would have been asking a lot of the appeals court. So I think it was more efficient for all involved to come straight here.
Well, are you asking us to overrule, or are you simply saying that the legislature has, in the view of our decisions, come to a different view and decided that the Mass Insurers Insolvency Fund is indeed a person in the business of insurance?
That's correct, Your Honor. What I'm asking the Court to do is acknowledge that the legislature has overruled the prior precedents.
Now, what do we do with Chapter 175, which speaks of all these rather extraordinary efforts to protect the assets of the insolvency fund, including barring payments to those with a very high net worth, making it the insurer of last resort, exempting them from all fees and taxes except for taxes on real and personal property? How do we conform your interpretation with the legislative protection of the assets that's incorporated in 175?
Your Honor, I actually believe that 175D has very little to do with this case. 175D deals entirely with how the fund responds to claims arising out of policies issued by insolvent insurers. 175D has never purported to address the issue of any kind of extra contractual liability, including liability for unfair claim settlement practices. That has been, the fund has consistently tried to argue, basically, if it's not in 175D, it doesn't count. And that is not the case. I gave the example in my reply brief of the fund certainly can be liable for simple breach of contract, even though 175D doesn't talk about that. It certainly can be liable for simple tort claims, even though 175D doesn't talk about that.
Right, well, I understand that, but I think they're saying if we're trying to discern legislative intent, and the legislative intent incorporated in 175D is to protect the assets, and if we open them up to liability under 176D Section 3.9, we are having another source of another assessment or another risk to those assets, which is going to deplete the fund and make it less available to other insureds.
That risk is really illusory, Your Honor. As I note in the reply brief, one thing that really looms very large over this case is the fact that property and casualty insurance in Massachusetts is a $10 billion, with a B, dollar per year industry. The fund has the ability to assess 2% of those premiums per year. That's $200 million, with an M, dollars. Historically, the fund has paid $15, $16, $17 million a year in claims and expenses. So the fund's ability to raise money is just staggering compared to what it actually lays out. And opening the door to Chapter 93A liability, especially in light of the fact that the fund's exposure under 93A is going to be relatively modest because of the $300,000 cap, it really is not going to affect the fund's finances one iota. And likewise, it's really not going to affect consumers, assuming for argument's sake that these judgments would be passed through to consumers. It's really not going to have a material impact on them. I gave the example in the reply brief of, hopefully this would be an unusual event, but if there was a $1 million judgment against the fund, that would translate to about 10 cents on a $1,000 policy.
Mr. Wheatley, that may be interesting, but it's not the way we look at statutory intent and statutory language. Could you tell me in what respect you disagree with the Superior Court judge's interpretation of the of 176D Section 1 as amended, which is why don't we take the second sentence as not including the insolvency fund?
Thank you, Your Honor. The problem with that analysis is that it breaks the rule that you don't look at statutory language in isolation. You have to look at statutory language in the context of the statute as a whole.
No, but so we do that, but first we look at what the language actually says.
If you look at the amendment in isolation, the court's interpretation is plausible. It is plausible that there would be a new and prior to 1996 unheard of category of entities that are, quote, persons but are not in the business of insurance. The problem and the flaw in that analysis is that that makes no sense when you then look at the statute as a whole, because all of the operative provisions of the statute, and in particular the key ones are Section 2, which makes it illegal to engage in unfair or deceptive practices in the business of insurance, and Section 5, which gives the...
I understand, but let's assume that you take Justice Gantz's point, that you've got a whole statute here, and essentially what the insolvency fund is doing is settling, is it not, claims made against insurers that are insolvent, correct? It's not in the business of denying insurance. It's not in the business of withholding insurance. It's not in the business of. It's not in that sense in the business of insurance. I mean, that comes back from the old cases, right? It's doing a rather unusual little specific thing.
That was the holding of Barrett. It's not in trade or commerce in the sense that it is not a for-profit entity, in the sense that it is a statutory entity. But
No, it's not because it's not for profit. It's because it's actually not in the business of insurance. It's actually...
It doesn't sell insurance.
It doesn't sell, and it doesn't decline to sell, and it doesn't set bad rates. And I mean, it doesn't do any of the stuff that insurers typically do.
Well, except that it processes claims. And that is
well,
a huge
it may
part
or
of the
may not.
industry.
It doesn't process claims in the way that the insurer would have to process a claim, correct?
I don't think that is correct, with all due respect, Your Honor. It processes claims exactly like any other insurer would process claims.
But if it didn't, I mean, an insurer processes claims of an insurance policy that it has sold, correct?
Correct?
So, I mean, isn't Justice Cordy right that being in the business of insurance means that you're selling policies?
No, I don't think so. I think that's one aspect of being in the business of insurance. But part of the business of insurance is responding to claims that come in under the policies.
But don't you have to be in all aspects of the business?
No,
Otherwise, you're not in the business.
No, I don't think that's true, Your Honor. I think that, for example, to take an example from another field, municipalities are not in trade or commerce for the most part, but in certain contexts they've been deemed to be in trade or commerce because of the nature of the activities that they're involved in.
But that's not in the business. I mean, this is a term of art, isn't? I mean, business of insurance. It isn't.
Actually, I'm not sure that it is a term of art, Your Honor. It is not a defined term in the statute, and that's one of the reasons we're in this difficulty. The statute only defines the term person and does not define in the business of insurance.
Mr. Wheatley, let me ask you this. Let's assume that you are correct, which is, as I take your argument, that Judge Lufo's interpretation is reasonable, but not when viewed as a statute as a whole. What's the purpose of the second sentence of the definition of person? In other words, why would it not read, for purposes of this chapter, all such persons shall be engaged in the business of insurance?
Your Honor, I think that is mostly a question of timing. That language was added later. If I've got the sentence you're referring to correct in my mind, the amendment adding the fund and joint underwriting associations was already accomplished at that point.
I understand, but implicit in that is that some persons are not engaged in the business of insurance. So somebody must have decided that some group of persons who are not engaged in the business, such as operators of any medical and hospital service plans and carriers and HMOs, shall be engaged in the business of. So implicit in that is that somebody's not engaged in the business of insurance.
Again, Your Honor, I think that's a case of looking at too narrow the statute in too narrow terms. I've already conceded that if you look at that particular provision in isolation, there's a case to be made that person and
I
in the business
understand
are two
that.
separate
I understand
things.
that.
But when you look at the statute as a whole, that just makes no sense. there is no room in the statutory scheme for an entity that is a person but not in the business of insurance.
But what about the fact that it gives the, as a person, the commissioner has authority to regulate, correct?
No, that's not correct, Your Honor. Again, the operative provisions, Section 2, which makes it illegal to engage in unfair insurance practices, and Section 5, which gives the commissioner, 5, 6, and 7, which give the commissioner its policy, its powers, all require that the entity not only be a person, but also be in the business of insurance. Sections 2, 5, 6, and 7 would be dead letters as to an entity that is only a person. And that is the problem with the narrow construction that the court adopted.
Well, you may be right, but let's go to Section 2. Section 2 says no persons shall engage in this Commonwealth in any trade practice,
Well, but it goes on.
which is defined. Yeah, it goes on, or an unfair method of competition, or an unfair deceptive act, or practice in the business of insurance.
Right, and it's the
So
last
no-
words, in the business of insurance.
Or
Or,
practice in the business of insurance.
Well,
I mean, so it says no person shall do any of these things.
I believe that the words in the business of insurance modify all of that clause.
has the
Your Honor.
commissioner opined on that, in your interpretation versus the alternative? That is that she, I guess it's a he now, has the power to regulate the fund in this way?
I don't know the answer to that, Your Honor. The commissioner has always had powers relative to the fund. That's even in Chapter 175D. The commissioner is given certain powers relative to the fund. I think the fund has always had to answer to the commissioner, which is another problem with the fund's argument in this case.
So you're saying that the fund's argument that the purpose of the amendment was simply to subject the fund to enforcement by the Commissioner of Insurance, that the fund was always subject to that type of enforcement?
Yeah, I believe that's true, Your Honor. 175D specifically gives the commissioner authority over the fund. It's open-ended. It's not defined the way it is in 176D, which specifically enumerates certain things that are improper. But there's a general grant of authority to the fund, to the commissioner over the fund in 175D.
Do the Attorney General's consumer protection regulations address this issue at
I
all?
don't believe they do, Your Honor.
Did I should know this, but when the amendment was made in 96, did the language did that add the language about 175 A, B, C, and E?
I'm not sure what you're referring to.
Well, let me see if I can find the statute. It defines this person, somebody in the business, and it gives the citations to Chapter 175A, 175B, 175C, and then 175E.
That was already there, Your Honor. That
That-
predates the 1996 amendment.
Okay, so all it did was add later on the fund.
The 1996 amendment could not have been more targeted. It specifically adds by name the fund and joint underwriting associations. And in view of the timing and in view of the like treatment, the identical treatment of the fund and joint underwriting associations, I think the inference is inescapable that that was a response to Barrett and to Posnick, which are the precedents which, prior to 1996, had effectively immunized the fund and JUAs from liability under 93A.
And because the fund and JUA had nothing else in common.
Not that I'm aware of, Your Honor.
Does
Not in
J-
1996 and not relative to Chapter 176D.
Does
Mr.
JUA
Wheat-
write insurance policies?
They do, Your Honor.
Mr. Wheatley, I'm sorry. Would you agree with the fund that this would be a radical change?
No, I don't, Your Honor. I addressed that in the reply brief, too.
I saw that.
This was, in 1992, at the time of the Barrett decision, the court was writing on a blank slate. There was no great body of history or public policy that dealt with whether the fund was or was not liable for bad faith claim settlement practices. The fund points to 175D, as the court has, and says, well, there's all these things protecting us in other ways. But as I said before, 175D was never intended to address and does not address extra contractual claims, bad faith claims settlement
But
practice claims.
if you take a look at 175D 5(1)(c), on which they rely, that says that the fund can pay claims, quote, in any order which it may deem reasonable, how can it do that if you're saying it has an obligation to essentially subject itself to that whole body of case law that we've said is a bad practice under the business of insurance, delay, all of those.
I'm glad you mentioned that, Your Honor, because that's actually another flaw in the fund's argument. The fund is now conceding, as they really have to, that they are subject to 176D. It's just that it can only be enforced by the commissioner. That's their position. If you're subject to 176D, whether it's the commissioner or a private action, you still have that conflict between Section 176D, Section 3, Subpart 9, and Section 175D, Section 5. That conflict is just as stark, even under their view of the case. So I don't really think that helps them. That conflict is there, but it doesn't matter either way.
And what do you make of the legislative history, that we deal with it the way we deal with most legislative history, which is to say there's no legislative history?
Unfortunately, that is the case, I think, here. The so-called legislative history that the fund has identified are really memos from the executive branch. They're really executive history.
Well, the executive branch has a lot of interest in the insurance business.
And in particular, in this case, they were interested in the commissioner's enforcement authorities, and that's what those memos address. The executive branch would not necessarily have been interested in what we're dealing with today, which is the private right of action.
The executive branch might have a real interest in making sure that the insolvency fund, which was set up for a very specific purpose, is not open to all kinds of other actions.
Well, that sort of brings us full circle, because one of the memos actually describes, I think one of the memos actually captures this case in a nutshell when it describes the fund as fundamentally an industry group that pays claims, and therefore it should be treated like the members of the industry. That really is what this case is all about. The fund has evolved into a surrogate for the industry at large, and just as the industry at large is subject to disincentives against unfair claim settlement practices, the fund should be too.
But what if the fund didn't exist? How would these claims get paid? Through bankruptcy court?
You would have to file some type of a claim with the receiver in the state, I believe, where the underlying insurer operated. For some reason, these receiverships seem to come out of Pennsylvania a lot, and so I think you'd find yourself in Pennsylvania in front of their commissioner of insurance filing a claim. And whether or not there'd be assets there to honor the claim, I don't know.
Thank you, Mr. Wheatley.
Thank you.
Mr. Tansky, good morning.
Good morning, Your Honors. Happy New Year. My name is Joseph Tansky. I represent the Massachusetts Insurers Insolvency Fund.
Mr. Tansky, let's look at sections 5 and 6 of 175D. You say this amendment was simply to make clear that the fund was a person under the jurisdiction of the commissioner and subject to some form of 176D requirements. But if you look at 5 and 6, the commissioner shall have the power to examine and investigate the affairs of every person engaged in the business of insurance. You say you're not engaged in the business of insurance, so the commissioner doesn't get any power there. 176, whenever the commissioner shall have reason to believe such person, i.e. a person engaged in the business of insurance, does these things. The commissioner can do all kinds of things. How does you being listed as a person get you under these sections?
I think the way you get there, Your Honor, is the fund is defined, of course, as a person in 176D, and then there's another section of 176D that says the following acts and practices are defined as being acts and practices, unfair and deceptive act and practices, and in the business of insurance. So it says these things are defined as being in the business of insurance, and then it goes on from there to say that the commissioner can regulate and oversee persons in the business of insurance. So I think you have to read the two things together.
Wait,
So what does
I
that
don't
mean?
understand what you, could you explain that again? I don't understand what you mean.
Yeah, there's a section. There's a section that defines the fund as a person, and then another section in 176D says the following lists of the following acts and practices are defined as
Which,
being.
can you tell me which section that
Section
is?
3?
Section 3.
Okay.
So are you
Page
saying that if you engage in an unfair and deceptive act, you're engaging in the business of insurance?
What I'm saying is if you do one of those things that is listed in 3, you are subject to regulation by the commissioner.
Even if you're not engaged in the business of
Yes,
insurance?
Because
yes,
there's an
exactly.
or there.
Exactly.
You say that
Because of the way they say you
You can do, it's unfair or practices.
Right. If you do one of those things, then you're subject to regulation by the commissioner.
You say that the purpose of the 1996 amendment was to to subject the fund to enforcement by the commissioner. But the plaintiff says that the commissioner always had that power.
That's really not accurate. The commissioner had the power under 175D to regulate the fund,
So those are the powers in Section 7?
Yes, you're
So
right.
what does the 1996 amendment give the commissioner that he or she did not already have under 175D7?
To take a look at the way the fund is handling a claim, for example, and if the commissioner doesn't like what's going on, to do something about it. And in my own view, the commissioner does not have all of the powers in 176D vis-a-vis the fund. For example, there's a power in 176D to levy financial sanctions on insurers. The fund is not an insurer, so the commissioner would not have that power. But the commissioner would have some other kind of power to, for example, force the fund to cease and desist from doing a particular bad thing.
What specific language are you referring to in the amendment that that would give the commissioner the power to decide whether the fund was properly handling claims?
It's in Section 5 with the Section 5, the section that gives the way it sets up, as I see it, is having defined the fund as a person. Then you look at Section 3, and it says the following are...
Section 3 of 176D.
176D.
176D, yeah.
Yes. The following are hereby defined as unfair methods of competition and unfair or deceptive acts or practices in the business of insurance. And then there's a whole list of things, many of which the fund does never do because it doesn't issue policies. Then, so it says these things are defined as being unfair or deceptive acts or practices in the business of insurance. And then, if you go to Section 5, it says the commissioner shall have the power to examine and investigate into the affair of every person engaged in the business of insurance in this Commonwealth. And I read that as meaning, referring back to Section 3. You could read it as saying the commissioner shall have the power to examine and investigate into the affairs of every person who's doing one of the things in Section 3. That's how I read it.
So if the fund the fund has the right to, or the authority to handle the order in which claims are processed. If a claimant has a gripe about the way the fund is processing its claim, it's reserving its claim, this particular claim, somehow, for some reason, for a late administration, the person could go to the commissioner and make complaint and perhaps even obtain redress.
Right, and if the commissioner took a look at that and said the fund is doing something terrible here, it would never get to that stage in the real world, but the commissioner would say to the fund, cut it out, and the fund would cut it out. If it had to be forced, there's a cease and desist power in 176D.
Mr. Tansky, I know these are very complicated statutes, but Section 5 doesn't talk about the power to examine and investigate the affairs of every person. It says every person engaged in the business of insurance in this Commonwealth.
I read that when it says engaged in the business of insurance, I read that as saying every person doing one of the things listed in Section 3.
So then you're saying that if you engage in those activities, you are in the business of insurance?
Yes, by definition. That's
Okay,
what
so then if
Section
the
3
fund
says.
then were to engage in an unfair and deceptive act listed in Section 3, then it would be in the business of insurance.
For purposes of enforcement by the commissioner under Section 5. In other words,
Why only for that purpose? Why
because
not for
that's
all
what
purposes?
because that's what the statute says. The statute 176D, I start from the premise it defines the fund as a person. They must have put it in there for some reason. They must have,
And is there any reason the legislature would be so subtle with regard to this amendment? I mean, this is a remarkably subtle legislative change you're suggesting.
well, I think they were being subtle, and I think that the way you see
It's the flip side of I'm sorry, go ahead.
I think they were being subtle because of the way they carefully parsed the definition of fund in Section 1 to not make it a person in the business of insurance by definition. Instead, the way they got to it is they said, yeah, the funds are definitely a person under 176D. We know that. It's got to have some meaning. What's the meaning? The meaning is Section 3 says if you do one of these listed things, these are bad things in the business of insurance, and then in Section 5, it gives the commissioner the authority to deal with those violations of Section 3. So it is a subtle phrase.
Put differently, they're not being subtle. They're being clear that they are not opening up the fund to endless claims of civil damages, attorney's fees.
Exactly, Your Honor. We're very careful to limit it to giving the power to the commissioner not to open the fund up to treble damages claims.
So
that was why it is so carefully parsed.
You're effectively adopting the same argument that Mr. Wheatley is making, that this legislation was in response to Posnick and Barrett. It's just that the legislature has selected a different route than Mr. Wheatley is suggesting.
And the response is to subject the fund to regulation by the commissioner, not to subject the fund to 93A claims for treble damages. That's the response, and that's why they were so careful in going about what they said.
I mean, isn't another way of looking at it that they, I mean, you're turning the English language on its head, aren't you? I mean, if you have person, you have Section 2, and it says the following shall be unfair, separates out person and business of insurance, and then 5 talks about person engaged in the business of insurance. I just
You have to read you have to read Section 5 as referring back to Section 3. Section 3 says anybody in the world who does any of these acts are hereby by legislative
why not
fiat.
just say person? Why add engaged in the business of insurance?
I didn't draft the legislation. I'm trying to square the legislation that they did draft with 175D, which carefully and thoroughly restricts the fund's obligations in any number of ways, which are entirely inconsistent with a reading that the fund is subject to 93A. I think the court has to remember that we really have 3 statutes we have to look at here. You can't just stop and look at 176D. You've got to go on and look at 93A and 175D and read them harmoniously so that you're giving effect to all 3 statutes.
Okay, well, now Chapter 175D, Section 7, 2C, gives the commissioner the ability to revoke the authority of any servicing facility of the fund if he finds claims are being handled unsatisfactorily.
Correct.
So the commissioner already had the authority to do the kinds of things you say was the purpose of this statute under 175D.
I think what the legislature was trying to do was the powers that are given to the commissioner in 176D are more express and they're more detailed than that language Your Honor just referred to. And I think the legislature was trying to make that clear when it added the fund in the definition of.
And if that was the case, wouldn't it have made more sense to add it to 175D, Section 7C, and say including?
I agree. It would have been. I would have drafted it that way. I didn't draft the statute. I had nothing to do with it.
Mr. Tansky, could I ask you this? With respect to the 176D, Section 1, the definition of person, and that second, or the last add-on sentence for purposes of this chapter, operators of any such medical service plans, does that sentence apply to joint underwriting association, JUA? I mean, what do we I'm trying to figure out, what is that last sentence clarifying?
Well, I think in the first sentence they talk about carriers and health maintenance organizations and insurers and sponsors of a legal services plan.
That were or were not in the earlier definition of person.
I think they're trying to say that the operators of those plans are deemed to be engaged in the business of insurance, to make it clear that that they are, because without that sentence there might be uncertainty as to whether they're in the business of insurance.
Right. But I understood from Mr. Wheatley that sentence came later.
I don't know the answer to that question, Your Honor.
Can you tell me whether or not person of any, Lloyd's, Yak, fraternal, operators of any medical service plan as defined in 176 BC, E and F, carriers and health and HMOs as defined in 176G. Were those added in 1996, or was the only addition the fund in 1996?
I don't think those were added in 76, but
So-
I'm not certain.
So only the fund.
Yeah. Only the fund and the reference to a joint underwriting association established by law. Your Honor, there are 4 provisions in 175D that I think the court really needs to take a look at when it's deciding this question.
175D?
175D.
Okay.
And that is, the 4 of them are the $300,000 limitation on covered claims, obviously a careful legislative intent to restrict the fund's financial exposure. The second one is the requirement that the fund pay only covered claims and deny all other claims. A covered claim is a claim that is within the coverage of a policy. A 93A claim is not a covered claim and would have to be denied by the fund. I think that's a positive expression of a limitation on the fund's power that an interpretation of 93A applies is totally inconsistent with that definition. The third we've already alluded to, which is that the fund can pay claims in any order it wants, including groups of claims. How can it do that and yet still have to respond to a 30-day demand letter under 93A that puts it at jeopardy of treble damages if it doesn't comply within 30 days with a offer? The fourth provision is a provision in 175D that says that actions involving the fund, and that has been construed to mean actions in which the fund is obligated to defend an insured, shall be stayed. It's a mandatory, shall be stayed for 6 months or such longer period as is required. Those are all very restrictive things that are totally inconsistent with a 30-day 93A treble damage provision. I don't
Mr.
think these-
Tansky, excuse me, one thing you mentioned in support of your position are these executive branch memoranda, which cite that the 96 amendment was to extend the authority of the Commissioner of Insurance to protect consumers. But why wouldn't, if the purpose was to protect consumers, why wouldn't that include or extend 93A and 176D so the consumer would be protected in that way?
Well, it does say that it's to protect consumers, but the mechanism, the remedy, the way to do that is referred to in all of the legislative history that we've cited, and it's the only legislative history, is enforcement by the Commissioner of Insurance. So it says, yeah, the Commissioner of Insurance is supposed to be looking out for consumers, but it's the Commissioner that has the power to do something about it, not some private litigant who wants to start a 93A action and look for treble damages where those aren't really the damages that they incurred. That legislative history, I think, is very compelling. There's no reference to a private right of action. There's no reference to 93A. There's no reference to this Court's decision in Barrett. It's all Commissioner of Insurance, Commissioner of Insurance, Commissioner of Insurance. And I think that's exactly what the legislature had in mind. I think if you step back, you have to conclude that no legislator had any thought whatsoever of turning 175D inside out, ignoring all of the 40 years of history that we have here, and suddenly saying the fund is subject to huge multi-million-dollar treble damage actions that are to be paid for by the public in the form of increased rates and premiums.
How would they be
just
explain multi-million-dollar liability?
Well,
If your limit is $300,000?
Well, that's the limit under the guarantee fund statute, but 93A says that your damages can be the amount of the underlying judgment, which can be a $5 million judgment if you happen to miss the clock. It can be a $5 million judgment trebled. It could be $15 million.
You say even the underlying judgment under 93A.
That's what the statute says. That's what the statute.
But it could exceed.
Yeah,
your-
and it says irrespective. In fact, the 93A is quite express. It says irrespective of the amount of insurance coverage involved. So insurance companies all the time get subjected to 93A damages far in excess of policy limits. That's the whole idea. So here my brother's suggesting that the legislature says you can be a paraplegic and you're going to get $300,000, and that's all you're ever going to get from the Mass Insolvency Fund, even if you had a $10 million policy. But the legislature said, oh, we're going to limit those people, but somebody else who wants to bring a 93A claim and ratchet up their damages because someone didn't respond in 30 days, they can recover $10 or $15 million from the fund and the public's going to pay for it. I don't think so. I don't think any legislator had that in mind. I really don't.
Thank you, Mr. Tansky.